So the Supreme Court recently granted review to the next big Second Amendment case, and once again it deals with state concealed carry restrictions and laws passed in direct defiance to their prior 6-3 ruling in New York State Rifle and Pistol Association versus Bruen. So let's talk about what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also double check to make sure YouTube is not unsubscribed you. And then also, I want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form's an amazing company, pro-freedom, pro-America. They support the Second Amendment, and they have great supplements. So if you're trying to get healthier this year, check them out using the link down below. And if you order any supplements, you can get a free 5-pack of protein sticks. As I mentioned in the intro, in this video, we're going to be talking about a two-way case that is set to be decided by the Supreme Court this term. And once again, it deals with concealed carry restrictions. The case we're going to be talking about is called Woolford versus Lopez. And this case is huge for people in states like New York, New Jersey, California, Hawaii, and others who are currently living under the new concealed carry restrictions that were passed in direct defiance to Bruen. Recently, to the surprise of many, the DOJ and AG Bondi stepped up in support of this challenge, and they called for these state concealed carry restrictions to be struck down as unconstitutional. That may have ultimately also helped the Supreme Court to break their track record of denying all of these emergency cases. And once again, the Trump DOJ has stepped up in support of this case, and now they're seeking to join those oral arguments that are going to happen in January. But also, you have 25 states who have filed a brief in support of striking down these concealed carry bans. But now also on the other side, you have 18 jurisdictions, primarily a bunch of states, that have jumped in support of Hawaii and their current concealed carry restrictions. Now, if you're not aware, this Woolford case is a challenge to Hawaii's new laws on concealed carry that they passed in direct response to Bruen. This law, like some other laws in different states, tried to add more restrictions to concealed carry and create this default rule where individuals can conceal carry firearms on private property that's open to the public only if the owner of that property gives you express permission to do so, oftentimes by posting a sign that says, yes, you can conceal carry at this location. So a bunch of plaintiffs, along with toy organizations, sued the state of Hawaii based on this law. And originally at the district court level, they got a preliminary injunction, which temporarily blocked this law and it blocked it from going into effect. Now that was appealed up to the Ninth Circuit by Hawaii, and on review, the Ninth Circuit ruled in favor of Hawaii. Now, after that, the plaintiffs sought for the Ninth Circuit en banc panel to review this case, but that was denied. There was a lot of conflict also on the Ninth Circuit by some of the justices saying that they should have taken review of this, but ultimately they denied review, and that led this case to then seek emergency Supreme Court review. And now the Supreme Court has granted review to this case, and they will hold oral arguments in this challenge on January 20th. Now, the question that the Supreme Court will answer in this case is whether the Ninth Circuit erred in holding in direct conflict with the Second Circuit that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. So that means that the Supreme Court will directly address this whole catch-all property ban that has been put in place in states like Hawaii in direct response to Bruen. Now, one of the critical things that may have led to the Supreme Court taking this case was the fact that the Trump DOJ jumped in support of this case. The Trump DOJ also jumped in once again, and now they're asking to actually participate during those oral arguments. In the brief submitted by the Trump DOJ, one of the first things that they argue is that Hawaii's affirmative consent rule actually violates the Second Amendment because it was designed purely to suppress concealed carry within the state. They argue that the law in question was not actually aiming to abide by Bruen or Supreme Court precedent. Instead, its underlying goal was actually to simply expand upon gun-free zones. They argue that Hawaii already protected property rights of those owners by, traditional trespass laws, and property owners could already actually forbid firearms on their property by simply posting signs like "No guns allowed." Now, after the Trump DOJ submitted that amicus brief, I stated that I believe they would also petition for the Supreme Court to allow them to participate during the oral arguments that are going to happen in January, and that's exactly now what has played out. In a recent motion, the Trump DOJ asked for the court to join those arguments, and we're going to find out soon if the Supreme Court is going to allow that to happen. So that's great news and would likely also be very beneficial to have the administration on our side during those arguments, and it will likely also potentially sway some of those justices that maybe are on the fence. You also have 26 states that have filed an amicus brief in support of our side to strike down this whole concealed carry restriction in states like Hawaii, California, and others. But now on the other side, you have 18 jurisdictions, pretty much a bunch of states, and then the District of Columbia, who have filed a brief in support of Hawaii's position, and they argue that essentially these new concealed carry restrictions are permissible even under Bruin. Those 18 states are the District of Columbia, Illinois, California, Colorado, Connecticut, Delaware, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New York, Oregon, Rhode Island, Vermont, and Washington. So some of those states may be not surprising at all because they also have these types of laws already in place in their state. For example, California, New York, New Jersey, and some others. And so they're advocating for these types of laws to be upheld at the Supreme Court level. The states argue that Hawaii's concealed carry restrictions aren't really a gun control law at all, but merely a neutral default rule about private property rights. According to that theory, they state that the firearms are automatically banned on private property open to the public unless the owner gives explicit permission, and the default supposedly reflects community norms and public expectations. So they point a lot to, some stats that they ran and some surveys that they ran in states like Hawaii and others, saying that maybe a majority of people would be in favor of this type of law. In their view, flipping the presumption in favor of carry would force business owners to take affirmative steps to just keep firearms out of their property, even though they already had that, right to do that and that ability to do that. And they have done that in the past also by simply posting signs. So there has been this tradition in America for a long time where if you did not want firearms at your location, you simply posted a sign, and that's your way of, preventing those firearms from coming onto your property. But here, essentially what Hawaii and these other states are advocating for is a state or government mandated presumption that that is unlawful unless the property owner says that you can do so, if you can, saying that you can carry at that location. Now, when it comes to the Second Amendment question, the states kind of take a hardline approach and kind of a position. They claim that the right to bear arms simply stops at the property line of the business owner. They argue that because property owners have an unquestioned right to exclude firearms, the government can step in on their behalf and codify a law that excludes, firearms from those locations. So the government can step in their place for the entire state and create a default rule, which also implicates the Second Amendment. Now, again, one of the things they fail to address is how this approach allows the government, not just the property owner, to decide the default and the outcome for the entire state. Not just for one property owner, but for all property owners, and put in place this default rule and this default law, which pretty much changes the presumption and flips it on its head. Here, these states argue that they can step in the place of all property owners within the state and create this kind of default outcome, effectively turning a personal property choice of a single owner into a state mandated prohibition that is overcome only if permission is affirmatively given by that single owner. Now, like I mentioned, this will all be heading to the Supreme Court for oral arguments on January 20th. This concealed carry case will be huge because it will be another case where the Supreme Court gets to perform the whole Bruin text, history, and tradition analysis, and that will give further guidance for lower courts on how to handle two-way cases going forward. Although I will state that many anti-gun states, like the ones who put forward this brief in support of Hawaii's law, will likely just try to find a way around it, or they will just outright defy it like many states did with Bruin. So this is still a huge case for the Second Amendment movement going forward. This term, the Supreme Court will once again hear a critical Second Amendment case. But for now, that's what's currently going on in this case. You have multiple states that are jumping in support of Hawaii and arguing that the Supreme Court should uphold these state concealed carry restrictions and that it does not violate the Second Amendment, that it doesn't even implicate the Second Amendment, and that there is a history and tradition which supports this type of law. So that's what's going on in this critical case. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.